In this video, I'm going to explain to you how to get divorced in Michigan in 4 steps. Hi, I'm Muthu Veerappan. I'm a criminal defense and civil litigation attorney here in Detroit, Michigan, and I help people fight for their freedom and protect their future. The first step is to identify the major issues you are having in the marital relationship to determine how the pleadings should be filed. When I say pleadings, I'm referring to the complaint and summons which you have to serve on the other party. If your spouse files first, then you will likely have to file an answer and a counter-complaint, also known as a counterclaim. An answer is a response to the allegations contained within the complaint for divorce. Now, it is possible that you have a custody issue outside of a marriage. In other words, a non-marital union results in a child, and then the parties break up and custody of the child still has to be determined. If there are concerns about transferring marital assets, such as property, or if one of the parties is preventing the other from accessing finances, then we can file motions and orders with the court. This ensures that you have access to the finances or assets at the very beginning of the divorce. It also prevents the other party from hiding money, assets, or selling them off without your permission. The second step happens once the opposing party files an answer. This allows us to move into the litigation portion of the divorce process. If the other party fails to respond, then a default judgment for divorce can be sought. During litigation, the parties exchange information through verified financial disclosures. This allows both parties to gather bank account information, home appraisals, tax returns, and any other relevant financial information. The third step is to ensure that any settlement is going to be fair, equitable, and just. This is usually done through court-ordered mediation. The mediator's job is to be a neutral third party that will listen to each side and assist everyone by coming up with the best resolution. If we're able to mediate successfully and come up with a settlement agreement, then we'll move on to the fourth step, which is finalizing the judgment of divorce. This will include all of the settlement terms of your divorce. Those can include child custody, child support, parenting time, property division, division of financial assets, and marital property. A judgment would be finalized at the next hearing before the circuit court judge. If the parties are unable to reach a resolution during mediation, then the matter will likely be set for trial. At the end of trial, the judge would deem an equitable and fair division of the marital assets. Family law can also include matters such as adoption, personal protection orders, also known as PPOs, and revocation of paternity. The worst thing you can do is initiate a family law case on your own because it could limit your options, increase child support, and result in the loss of custody and parenting time with your children. For all of these reasons, you need to speak with a professional before you make any decisions that could make your case more difficult to litigate. We're ready to help you, we're open 24/7, and I'll give you a free consultation. You'll sit with me and we'll review your case and see what options you have available.
This video is not legal advice and should not be relied on for legal advice. Be sure to consult with an experienced attorney whenever you have legal issues.